Okay, everyone, some new filings in Don Lemon's criminal case. And the big news is the district judge, Laura M. Provenzino, who will be presiding over the trial, is now requiring the government to produce all grand jury materials for in camera review. That is, privately to the judge in chambers, no copies to the defendants or the public record. So, this week, the government was ordered to provide the judge with access to all materials that the government presented to the grand jury on January 29th and February 26th, which resulted in the indictment and superseding indictments. It's what the defendants have been asking for months, and we might think, well, the defendants just got everything they wanted, didn't they? Well, only if the grand jury materials show government misconduct, and last week it didn't. Last week, the government produced in camera for the magistrate judge, Douglas L. Miko, who's been ruling on pretrial motions all these months, grand jury witness testimony relating to journalist co-defendants Georgia Fort and Michael Butte. And big surprise, the judge found no misconduct by the government before the grand jury relating to witness testimony about Georgia Fort and Michael Butte. Now, Georgia Fort's attorneys were upset by that finding. They were, so they filed yet another motion. Now, last week they filed over 1,000 pages. They can't stop themselves. This week they asked for disclosure of more than just the witness testimony before the grand jury regarding Georgia Fort and Michael Butte. They want all materials, including the full transcript of remarks made by government attorneys and agents to the grand jury outside the presence of witnesses. So it was like a double dare. Georgia Fort's attorneys are saying to the court, to both judges, we double dare you, disclose everything. And the court was like, okay. So this is what happened this week. Now, as I mentioned, the district judge ordered the government to produce for in-camera inspection all grand jury materials. Now, the activist-defendants theorize that government attorneys misled the grand jury regarding the law. They say that the DOJ's public comments around the time of the indictment in January suggest that government attorneys must have told the grand jury that there was a national emergency that needed to be quelled, and it's no problem, of course, if the defendants make those types of statements. They're crafting a rule here that applies for me, but not for thee. Now, the filings by defendants last week even discussed ICE agents allegedly trapping a family in a car as it filled with chemical gases. They discussed what happened to George Floyd and Breonna Taylor as well, as if those incidents happened to Don Lemon and his co-defendants. And yet, now they're saying if the government talks to the grand jury about a national emergency of violence directed toward ICE agents, the indictment must be dismissed. But of course, we follow that logic. Now, Don Lemon and Georgia Fort also allege that government attorneys and agents must have told the grand jury that Georgia Fort was chanting anti-ICE slogans in the church, which she absolutely did not, allegedly. Now, as I discussed last week, that's an issue of fact for the jury to determine, the trial jury. Now, as we understand, though, for weeks now, there's been increasing desperation from Georgia Fort and her attorneys. She really doesn't want to be convicted, and there's a civil case against the co-defendants as well. So the court proceedings won't be over for quite some time. Now, civil cases can drag on for years, and the parties in civil proceedings are a lot less polite to each other than in criminal proceedings, because in criminal, one of the parties is the government, so we'd all best be on good behavior. Now, in civil, it's different. It's private parties fighting each other with very little intervention by judges. Now, Don Lemon and Georgia Fort also allege that government attorneys should have instructed the grand jurors that First Amendment activity is protected and not prosecutable under the FACE Act and KKK Act, allegedly. I mean, they're really hunkering down into their legal position, which is to emphasize an alleged primacy for freedom of the press in contrast to the rights of worshipers under the First Amendment. Now, it's a politically radical interpretation of the First Amendment. So, in my view, the district judge isn't taking that part seriously. In my view, the district judge just wants to find out if there's anything there in the grand jury materials, which was the same driver for the magistrate judge 2 weeks ago, when he ordered an in-camera inspection of grand jury witness testimony referencing Georgia Fort and Michael Butte. He found no government misconduct, and I don't anticipate a different result with the broader disclosures ordered this week. And just to conclude, Don Lemon and Georgia Fort allege that the prosecution fits comfortably within the DOJ's pattern of bringing deeply flawed prosecutions to appease administration officials. They cite public remarks from the DOJ at the time. Now, we all heard their comments or read them on social media. Their comments were very strong, and I thought permissible for the DOJ, which is part of the executive branch, which is the law and order branch of government. Now, it's part of the administration's messaging. Now, the issue for this case, the Don Lemon case, is did the administration's messaging interfere with the course of justice? Of course not. The DOJ was just trying to make law and order relevant again. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.